Give your attention the Honorable Justices of the Montana Supreme Court.
Good morning. My name is Mike McGrath. I'm the Chief Justice of the Montana Supreme Court. And first order of business, I think, is to make sure that we've got all of the members of the court up here. I know that everybody's around. Thank you for giving us an opportunity to appear by Zoom. I see that Justice McKinnon is here. Justice Baker is here. We also have on the court Justice Ingrid Gustafson. I don't see her, but I bet she's here. Justice Dirk Sandifer, Justice Jim Shea, and Justice Jim Rice. Bowen, is everybody visible? Can you tell? Okay, thank you. Bowen Greenwood is the clerk of the Montana Supreme Court. So this is cause number DA 200609, Wittman versus City of Billings. You've had an introduction about this case, a brief explanation. So we will jump into the argument. And I think Mr. Gannett is, going to begin.
Thank you, Chief. Good morning. May it please the court, counsel, members of the bar. My name is Tucker Gannett, appearing on behalf of the appellants, Ariane Wittman and Jeremy Taylen. I'll be ceding 10 minutes of my time to amicus counsel Rafe Graybill, and we'll be reserving 10 minutes of time for rebuttal argument. In Deschner, this court set forth the elements a plaintiff must prove in an inverse condemnation claim. 1, that the public improvement was deliberately planned and built. And 2, that as planned and built, the public improvement proximately caused damage to the plaintiff's property. The case before this court satisfies both of these elements. There is no dispute in this case that the city's sewer system is a public improvement that was deliberately planned and built. To the extent that any private property had to be taken for the construction of the 500 plus miles of city sewer mains, sewer is an enumerated public use in Title 70-30-102, subsection 39 of the Montana Code. There's no dispute that the cause of the sewage backup in this case is a grease clog on the city's main sewer line. We're not talking about lateral lines. We're talking about the city's main sewer line. And 10 to 15 similar backups on average happen every year in Billings. And they have happened every year for the past 40 years in Billings. There's no dispute that Ariane Wittman and Jeremy Taylen did not dump that grease into the system. Nor is there any statute or local ordinance that restricts or limits residential grease discharge. There's absolutely nothing Ariane and Jeremy could have done to prevent this catastrophe, and the city will not dispute that fact. There are 3 reasons why this court should reverse the district court and remand for trial. The first is that Montana inverse condemnation law requires deliberate governmental action, but not the type of tortious intent that can support the intent to harm standard adopted by the district court. The second reason is that affirming the district court would require this court to chart a whole new path on inverse condemnation and foist the cost of these inherent and unavoidable overflow events onto the completely innocent victims going forward. The third reason is that under our state constitution, Montana citizens have a fundamental right to be compensated for the consequential damage their property sustains incident to public works projects.
So Mr. Gannett, what's the difference? I'm sorry.
No, go ahead, Chief.
Mr. Gannett, what's the difference between your argument and strict liability argument?
There's a significant difference, Chief Judge. The notion that this is strict liability in this case has come up only because the causation element of this test is undisputed. Inverse condemnation, we have to find two pieces. First, we have to find that the public work as deliberately planned and built caused this damage. And there it is, the second part, proximately caused the damage. So what's interesting is that in the Deschner case, the district court actually granted summary judgment for the plaintiffs, stating that the highway department had taken deliberate action by installing the culvert underneath the highway. It moves the water from the north side of the road to the south side where the water falls into this tension crack. So the plaintiffs in Deschner actually got to the jury on whether or not this was the proximate cause of their damage. And as the court knows, the jury returned a defense verdict saying that this was not the cause. So there is a great deal of difference between what we're arguing for here and strict liability. It just so happens in these circumstances, if we get past this liability phase, there is no dispute that it was the clog in the city sewer main that caused 1,000 gallons of sewage to end up in Miss Wittman and Mr. Taylen's home.
Well, Mr. Gannett, my question has to do with a little bit more threshold issue when you talk about the fundamental right to compensation for damage and the second element of the inverse condemnation test. And the more threshold question is whether there has been a compensable damage or taking in this case. You've cited Rouser for our statement about when the damage is an inevitable result of the intentional undertaking, so on and so forth. But in that same case, we said it is implicit in inverse condemnation that the extent of the damage be of such degree as to amount to a taking of an interest in the property damaged. And in the subsequent cases, both the Knight cases, Adams, we've talked about the measure of damages being the difference between fair market value of the property before and after the condemnation, the inverse condemnation. Have we, I guess the question is twofold. First of all, I don't see anything in the summary judgment materials in which the plaintiffs claimed or established any element of damage relating to diminution in value of their property. And the materials include the responses to interrogatories, which set out their elements of damage, which are for cleanup and replacement of some personal property, but nothing claimed on diminution of value. Is there a case that you've found where we've recognized an inverse condemnation claim without a diminution in value? And is there such a thing going on in this case?
Yeah, so very interesting question, Justice Baker. Raw sewage is a huge health problem, right? So in this case, we had 1,000 gallons of sewage come into the Wittman and Taylen's home. The main line was jet cleaned and the sewage receded. So what these folks were left with was a basement that had sewage stains about 2 inches up onto their baseboards and drywall. All of their belongings, the floor coverings, carpet, linoleum, all of this was damaged. In order for this to have stayed a diminution in value case, the plaintiffs would have had to walk away from their house because they couldn't live there. As a matter of their own health and safety, they had to get the people in to do the remediation work so that they could continue to live in their house. So if the plaintiffs had chosen in this case to stick to the diminution in value method, they would have moved out and marketed the house for sale at a significantly reduced price to whoever could fix it. And to answer the second piece of your question, I'm not sure that there's been a distinction in Montana law between property damage caused by an inverse condemnation and property damage caused more generally. And what we have in Montana is the Lampe case. And the Lampe case says, generally speaking, a diminution in value is the measure of damages in a property case, unless there are reasons personal to restore the property. And almost unanimously throughout the application of that Lampe rule, this court has ruled that a person's personal residence, there will always be reasons personal to restore your own residential home.
Thank you.
The problems that inverse condemnation solves is when the government forces a few individuals to bear an economic burden which should be borne by society as a whole. In this case, we have 10 to 15 sewage overflow events that happen every year. And that is the average number going all the way back to 1980. So in the last 40 years, hundreds and hundreds of people in Billings have been forced to bear the burden of this cost when it is a regular part of operation of the system. This court does not consider things like fault or negligence when we talk about inverse condemnation. Again, the Deschner test was a public improvement deliberately planned and built, and as planned and built, did it approximately cause this damage? Which brings me to my first reason to reverse the district court and remand for trial.
Mr. Gannett, excuse me, if you could focus a little bit more on that second prong, which is approximate cause. I imagine Mr. Fagan is not going to agree that the issue of causation is automatically established. And how does that work into the analysis? What are we supposed to be looking at in terms of addressing that proximate cause issue?
So causation, thank you, Justice McKinnon. Causation and damages in inverse condemnation law in Montana is a jury issue. Again, looking back to Deschner, the district court said that the Deschners had satisfied the as deliberately planned and built element and allowed the jury to consider whether the water coming through that culvert actually caused the big chunk of rim rock to slough off the house. So the issue of causation is not before this court on this appeal at all.
So you're asking for a remand on that issue?
No, what I'm asking for, thank you, Justice McKinnon, is a finding by this court that sewage overflow events constitute it's part of the deliberate plan of the sewer system so that we can go back and remand, yes, and have a trial on causation and damages.
Thank you.
In the district court's order pending appeal, the district court injected what I'm going to call an intent element into Montana inverse condemnation law that has not historically existed. On page 9 of the district court's order relying on Nebraska law, the court noted that the government action must, quote, intend to invade the property. Relying on Texas law, the court stated that the intent must be to damage private property. And based on this ruling, the city in its brief on appeal states that to prove that a taking had occurred, it was necessary to show that the governmental entity had intended to invade the property owner's interest. Now, this exact argument was made and rejected by the court in Rouser. This court in Rouser noted that the irrigation district had cited to the Montana case of Fleming versus Lockwood for the proposition that to have a recovery under inverse condemnation, there must be, quote, intentional or negligent acts. The Rouser court disagreed and stated that where the damages are inevitable, an inevitable result of the intentional undertaking, the inverse condemnation liability attaches. And the Rouser court added really important context to this holding. It said that certain unexplained and unplanned for problems that damage adjacent private property owners will arise. The Rouser court went on to state that, quote, in many instances, there's no negligence or other wrongful conduct or omission on the part of the condemnor. Now that language in Rouser swallows up this notion that there needs to be an intent or desire to cause identifiable harm. This is completely incongruent with more than 120 years of inverse condemnation law in Montana. Again, turning to Deschner.
Let me interrupt you here for a second, because, and I guess 2 points on that. I mean, so what significance do you ascribe to the word deliberately planned and built then, because, and I agree that intent is maybe a misnomer in terms of the use of that word, but you know what, a sewage system is deliberately planned and built to carry sewage. And you can build a straight stretch of 4-lane highway and it's deliberately planned and built for people to get from point A to point B. It doesn't mean that if somebody uses it to go 110 miles per hour, that's what the intent was. So I guess in this, I somewhat dovetails with your, I guess that's the first part of my question. The second part is, in Taylen versus City of Billings, we talked about the causation element. And I know you say it's not present, but this court held that the test was whether through a natural and continuous sequence unbroken by any new intervening cause produced plaintiff's injury. Well, is the grease that was injected into the sewer system an intervening cause that effectively abrogates any causation?
Sure, thank you, Justice Shea. Answering the first question, and you hit on it perfectly, the deliberate government action is deliberately planning and building a system that has inherent risks. And if those inherent risks materialize and cause private property damage, that deliberateness requirement is satisfied.
So if somebody is driving 120 miles an hour down a straight stretch of I-90, can the state be held liable if they then cause damage to somebody? Because it was built in a manner that has inherent risks. You build a good stretch of highway, somebody's going to speed on.
The answer to that question, Your Honor, is no. And there are a few reasons for that. The first is, and maybe the most important, in every one of our inverse condemnation cases, we've been presented with a plaintiff who is absolutely helpless to prevent the harm that was foisted upon them. In Root Butte, we had a railroad that was going through the middle of town in Anaconda. Mr. Root couldn't have done anything to make that train stop whistling in the middle of the night. In Night Billings, we had a road that was expanded from 2 lanes to 4 lanes, and the people who own property on the west side of the road could not do anything to get less traffic on the road that would replace the value in their home. And so the example that you've made, Justice Shea, is easy to get caught in, but the answer again comes back to causation. Would the design of the road be the proximate cause of the damage? And the answer is no. Drivers have an obligation to maintain a lookout. They have an obligation to drive reasonably and prudently. They have these other causation issues that would prevent the liability from landing on the city. And I'd also add,
so if the city passed an ordinance that prohibited private citizens from discharging grease into the sewer system, would that then address the issue and effectively immunize the city from any at least inverse condemnation claims?
It could. I think the better example would be what happened in Oroville, where the city required all homeowners to install a backwater valve on their homes to prevent this type of overflow from coming in. I don't know how anyone could enforce residential discharge restriction. I mean, we'd have to outlaw the sale of sink garbage disposals, I suppose. And I mean, it seems like it would be something that could not be enforced. But theoretically, yes, Judge, that would be the type of thing that the city could do to protect itself from these claims.
Mr. Gannett, doesn't that kind of provide some substance to the idea that the design of the sewer system here wasn't the proximate causation, didn't cause the damage? If you're talking about installing devices in people's sinks to prevent the grease flow. I mean, how do you design a sewer system, that allows for that type of protection to landowners?
Well, again, that would be in the Oroville case where the city ordinance required, and it's not in the sink, Justice McKinnon, it's on the sewer lateral line. It's kind of a backwater valve that would stop these overflows from getting in. I guess going back to the first part of the question, I don't think it cuts against the argument because that option is available to the city. But where we're at right now is we're at a spot where both the city's 30B6 designee and their expert said that there is no way to design a system that will not get clogged by grease. They described it as a nationwide problem, and the district court in its order called these overflow events 10 to 15 annual inevitable overflow events. And the purpose of inverse condemnation is to ensure that something that is bound to happen incident to a public works project, the cost of that is not placed on private citizens. And I see I've only got about a minute left, so I'd like to discuss a little bit the history of this inverse condemnation clause. This eminent domain provision in the Constitution is as old as this state is. It was around in 1889. In 1972, it was amended by the constitutional delegation. It actually added greater protections for the private property owner in 1972. We said that the compensation must be, quote, to the full measure of the damage. We also added a second sentence about litigation expenses. And this eminent domain provision is now and always has been in the Declaration of Rights. And this court has held time and time again that rights found in the Declaration of Rights are fundamental because they comprise a large component of liberty, and they must be given the absolute highest protection by these courts. Montana has found a broader right to privacy under our Constitution. Montana has said that the right to exclude is perhaps the most fundamental property right that we have. Yet here we have a situation where Mr. Taylen and Ms. Wittman are unable to even exclude other people's sewage, let alone the other people. And I've just dipped under my first 20 minutes, so I'm going to now defer to amicus counsel, Mr. Graybill.
May it please the court, my name is Rafe Graybill on behalf of amicus. This is at its core a property rights case. The rule in Montana has always been that when government damages private property through no fault of the property owner, government pays. In this case, the city of Billings deposited 1,000 gallons of raw, untreated sewage into Ms. Wittman's basement. Everyone in this case agrees it was not her fault. And furthermore, there's nothing she could have done to prevent it. Everyone and the district court agree.
Mr. Graybill, going back then to the question that was asked of Mr. Gannett, then what you're effectively arguing is strict liability. I mean, what you just said is whenever government causes damage through no fault of the homeowner or the property owner, government pays. How is that not just strict liability?
Well, I think the difference here is in the proximate causation requirement or the reason or the substantial causation requirement that we've argued for in the amicus brief. Justice Shea, you asked about, for example, and Justice McKinnon as well, what of the issue of third parties dumping into the sewer? Now, admittedly, if you read the city's brief, you get this image of someone furtively pouring grease down the sewer up the street from Ms. Wittman. And no one contends that's what happened in this case. When the city talks about third parties pouring into the sewer, that's really just code word for users of the system, people washing their dishes, using the system as it was designed. Now, cities have tools in this situation to prevent inverse condemnation liability from attaching. This is where the Oroville case is particularly useful. As Tucker mentioned, in the Oroville case, the city wanted fewer of these overflow events to occur. So the city passed a law saying that everyone, not just industrial users, but residential users too, had to install these backflow valves. And when the California Supreme Court examined that case, it said, well, because these dentists didn't install the backflow valve, we can't say that the design of the system was a substantial cause of the damage they suffered. Now, the city of Billings is allowed under inverse condemnation law to make the choice that it did. It chose to deliberately build, maintain, and operate a system that everyone agrees inevitably is going to result in 10 to 15 of these events a year. Under this court's case law, that's reasonable.
Well, nothing precluded the homeowners from installing these backflow valves either, correct? I mean, if that's the question, if it's that simple, then if it's a question of was it the city's obligation to impose that obligation onto the homeowners, or the fact that the homeowners elected not to do it, or their predecessors, whoever originally, or the developers, whatever, that they chose not to do it, how is that any different?
Well, I think a standard like that would not only depart from this court's existing case law, but it would move away from what the Constitution is trying to solve with inverse condemnation, right? Inverse condemnation is where the government comes in and takes or damages, in our Constitution, your property. And if we adopt a new standard that says citizens whose property is damaged or taken have to undertake extra steps to avoid that damage, I really don't think there's support for that in the Montana Constitution or our case law. The test is really rather simple, as articulated in Deschner. You've got to show that the public improvement was deliberately planned and built, which is clearly satisfied here. And you've got to show that as designed and built, it proximately caused the damage. I don't think there's any serious dispute that the city of Billings, I mean, they admit this, that their system is going to cause 10 to 15 of these overflows every single year. Inverse condemnation law allows cities to make that choice, but in so making that choice, they accept the attendant responsibility of compensating people who they know they're going to damage. Where the district court went wrong in this case, respectfully, is saying that the city somehow had to imagine which people in this group it was going to damage. This is where the intent focus was perhaps a bit off by the district court. Now, if this court affirms what the district court did here, it takes a radical departure from its existing case law on inverse condemnation. That would essentially collapse the distinction between traditional eminent domain and inverse condemnation. Just hold that the government has to know, even though we're going to hurt this group of people, we have to predict which people we're going to hurt and in which way. That simply isn't how inverse condemnation works. It's not its function in the Constitution, and it's not how traditional eminent domain works either.
Mr. Graybill, how would you send this to the jury to decide? Are you asking would you ask the jury to evaluate the city's choice in the sewer system that they installed? And what factors go into that? How old is the sewer system? Is that, I mean, do you replace the sewer system? I mean, and what about the implications of having a jury assess that whole decision itself?
Well, I think that the policy choice about which system to design and how to design it belongs to the city. And it's not something that a jury or a judge reevaluates. But I do think that what a jury or a judge looks at is, given the choice that the city made, what are the foreseeable consequences? What are the inherent risks, in the language of Oroville? What do we know is going to happen? And in this case, what we know is that the city of Billings, the way it runs its system, 10 or 15 people every year are going to get these damages in their homes. That was, the language in Rausser and Deschner is foreseeable. The city of Billings admits it's more than that. It's inevitable that this is going to happen. And it's in exactly these kinds of situations that inverse condemnation law ought to function. You've got the true costs of operating a public improvement. It's not just the money the city budgets, but it's also the cost of damaging these people we know we're going to damage every year. And the question becomes, should those individual citizens who were helpless to stop it, should they pay or should the government pay? And our Constitution, dating back to 1889, has said, in that situation where we knew this damage was going to occur, where the people were helpless to stop it, the government pays. And again, Oroville is particularly useful because it illustrates inverse condemnation is not boundless. And there are things that cities can do to reduce their liability. The city of Billings here could have adopted an ordinance saying that people like Ms. Wittman need to install backwater flow valves on their homes. They didn't, and they're entitled to make that choice. But in so making that choice, under our Constitution, they're also responsible for compensating her when they damage her in ways that were entirely foreseeable, indeed inevitable. One of the things I'd like to mention briefly in my last minute or so is the Oroville case. It has two contributions really here. The first contribution we've talked about, which is it gives this court a real world example of how cities, local governments have tools to avoid inverse condemnation liability. It doesn't open the floodgates to say that this particular problem sounds an inverse condemnation. The second thing that the Oroville case does is it offers a way, without changing the substance of the test, without moving the goalposts, it offers a way to talk about inverse condemnation that doesn't borrow any terms from negligence law or tort law. And this court has been very strict over the years in preserving the boundaries between the tort requirements, negligence requirements, and inverse condemnation. They function distinctly in our legal system. And because our case law on inverse condemnation looks at California law, setting aside the Albers factors, we adopted the Albers test in Rausser. We reiterated that test in Deschner. The California Supreme Court looked at that same language and said, we also care about separating tort, negligence, and inverse condemnation. And a better way to articulate the same test that doesn't move the standard at all, but articulates it differently, is substantial causation, which makes sure that the government conduct is linked in an important way to what happened, and inherent risk. What inherent risk does is it moves the focus away from the mental state of the government agency or government actor and moves it towards the propensities of public works to damage citizens. The intent requirement, as we talked about before, is sort of what may have set the district court astray in this case, again, with respect to the district court. The intent requirement is easily satisfied under Montana law. I don't think anyone questions that the Billings sewer system was built intentionally. But talking about substantial causation, inherent risk, I think offers district courts a better guide under the same standard to analyze these kinds of problems.
Council Rice here. I understand your argument that the system was intentionally built, but I don't think under condemnation law, that's really the meaning of intent. We've talked a lot about causation today, but there's a lot more to condemnation than causation, and it arrives in this area of intent. Under the constitutional provision, and despite the fact we have a lot of cases that use different terms, the intent is to take a piece of property, private property, and to convert it to public use. That's the intent. It's not the intent to damage someone's property under condemnation law. If it's an intention to damage someone's property, that's a tort. I mean, the government can be held accountable for that, for an accident. Oops, we built this system and we accidentally damaged your property. We should have foreseen it. Okay, that's not condemnation, that's a tort. And so I think the question is here, in terms of properly determining the intent of it, did the government here have the intention to convert your client's property to a public use? And it seems to me that that's a much more difficult hurdle you have to establish.
Well, and briefly, I would say that they did. The city of Billings operates a sewer system it knows will do this to 10 to 15 people a year. It always has, and it knows that Ms. Wittman is in that group. So that, to my mind, that is the classic case of inverse condemnation. If the government knew specifically that Ariane Wittman's home would be inundated with sewage on this day in this way, that looks more like traditional eminent domain. But what happened here is what inverse condemnation calls for in our Constitution. The government did something, it caused foreseeable damage, and it injured a property owner through no fault of their own.
Thank you.
Thank you. I'll see the rest of my time.
Mr. Fagan?
Thank you, Chief Justice. Can everybody hear me?
We got you.
Thank you very much. I'm here with my co-counsel Afton Ball, and I'd just like to initially thank the court for taking time to hear this case and to consider the parties' positions. Because while it's not, I think, the most appealing a case because it involves a sewer backup, it is a really important case. It's an important case because it has statewide implications for all the governmental entities, cities and towns, the county governments, and the state government that all operate across the entire state, many different types of public improvements. And the decision in this case can affect all those public improvements statewide, and it is a critical decision. Because I do think, as some of the justices have noted, that the appellant's argument is essentially seeking a strict liability finding. And that's not been the Montana law, and it should not be the Montana law going forward. That being said, the district court did, in our opinion, properly act, and the district court's order should be affirmed. The district court properly applied the existing precedent on Montana law on inverse condemnation, and that's primarily the Rausser and the Lodge-Deschner cases. And it did apply that appropriately to the facts in the record.
Mr. Fagan, excuse me, what authority is there in Montana to support the proposition that you just stated, That is, that there needs to be negligent or intentional damaging or negligent or intentional causation of private property, because there is none to my knowledge.
Thank you for your question, Justice Sandifer, and I agree with you. And I'm not saying that there has to be some type of intentional or negligent act that caused this. What I think the case law says, Justice Sandifer, is that there needs to be a deliberate decision or a deliberate choice by the governmental entity when they're constructing or designing or maintaining their public improvement that caused the backup in question.
And how is that not here?
Because there's no showing that the city did anything in terms of designing their sewer system or constructing it or maintaining it that caused that backup.
How is that not an argument that there has to be an intent by the city to cause particular damage?
It's not, I'm not trying to argue an intent to damage. It's an intent to make a decision that can be shown through the evidence that it caused that backup issue. And
Isn't that just a negligent design? I mean, it's either a negligent design or maintenance is basically, aren't you arguing that they have to have negligence or intentional desire to have a bad system?
no, I'm not arguing that, Justice Gustafson. What we think needs to be shown is that the city made some deliberate decision or choice, such as they decide to forego maintenance, which in some systems, these cities do decide that we will not maintain this, we'll wait till it breaks. That's an actual deliberate government decision. And if that can be shown to have caused the backup in question, then that's the decision that triggers a takings. That's the type of thing that that we say needs to be existing to support an inverse condemnation claim, and it does not exist in this case.
So I
Mr.
guess-
Fagan, that disregards the intentional decision that the city made in the first instance to build a sewer system that on this record has an inherent risk of this type of thing. So I think that your argument wants to gloss over that troublesome analytical step in this.
I think if we looked at the Rouser case, Justice Sandifer, it's instructive as how these cases are decided. In Rouser, there was an irrigation district that was deciding whether to build an irrigation project. And they had been warned in the USGS survey that if they did so, that it would inevitably flood the adjoining land. And then they made that choice to construct the project. And it did flood the adjoining land, and that adjoining landowner did file an inverse condemnation claim against the irrigation district. This court in Rouser did not hold that you built the project and it flooded, therefore you took the property. This court instead analyzed the decisions that the irrigation project took and what it knew at the time, and to see if there was a deliberate choice to build this project in a way that caused that damage. What the distinction is, you can say two types of liability. You built the project and it flooded, therefore you're liable, or you built the project and we need to see what type of decisions you made when you built that may have triggered that later damage. And
How
that's
about
the
you
distinction
built the
between-
project and you knew that it had an inherent risk of doing this type of thing?
Okay, let me talk about the inherent risk, because I think it's important to correct the record on these overflow events. They are being greatly exaggerated based on the actual facts in the record. There are on average 10 to 15 overflow events per year in the Billings system out of over 32,000 hookups. But those are not all grease backups. There are a variety of different things. There's rags get interjected in the system, rocks get interjected in the system, manhole cover gets disrupted and blocks the system, tree roots grow into the system. Those trigger overflow events. If you look at tab number 10 to the plaintiffs or to the appellant's appendix, you'll see they've listed the overflow reports for grease backups. And there is on average 1 to 2 per year total of grease backups. These other 10 to 15 that happen are all sorts of different overflow events, and they're not of the same magnitude too. Many of them are 1 to 2 gallons. So there's the idea that this is an inherent risk that the Wittman home is 10 to 15 people suffer that every year is not true based on the record.
Are you suggesting, and I guess you are, but I want to make sure that this record is clear, that sewage backups are not recognized by the city of Billings or any other municipality in this state to be a inherent risk and not uncommon occurrence, regardless of whether it's grease, rags, or whatever else people put in to these into the sewers. Are you really suggesting that?
Well, I would say that it's not common when you have 10 to 15 overflow events out of over 32,000 hookups. There's over 500 miles of sewer line in the Billings area. That's a minuscule amount out of over 32,000 accounts hooking into that system. But there are ongoing issues with overflow events in any system. But the important part for this case is we need, under the existing precedent, to show that the city made some type of design choice or maintenance choice that caused those backups. And
So what would you think about this court adopting the, in effect, the Oroville standard, the California standard, that you've got a system with inherent risk and the damage was substantially caused by that inherent risk?
Thank you for bringing up the Oroville case, Justice McGrath. There are, two issues with that. The first issue is, of course, that Oroville was never argued to the district court. And under this, this court's precedent, which you all know better than I do, this court can't consider legal arguments that were not made to the district court and be made to the Supreme Court. Now, the appellants have tried to argue against that in a reply brief, saying that they're not introducing a new legal argument by introducing Oroville. They're just introducing an argument that bolsters or emphasizes their previous arguments to district court. And that's simply not true.
Mr. Fagan, what is true is that the rationale in Oroville is consistent with precedent that we have in this state.
I would agree it's not that much different, but this court, in my opinion, cannot consider it because it was never offered to the district court. And the appellants are asking this court to adopt the Oroville holding and apply it. And that would effectively mean you have to overrule Lodge-Deschner, which this court only considered 4 years ago. And I see no justification to overrule Lodge-Deschner just because the appellants feel that a case out of California better suits their purposes.
Forget Oroville. On what basis, if we apply existing precedent in Montana, do we have to overrule anything in Montana?
I don't think you do, Justice Sandifer, if you don't adopt Oroville. But what I was saying is that the appellants are asking you to adopt the Oroville holding, which will effectively overrule Rouser and Lodge-Deschner because it changes the elements. I don't think the court should adopt Oroville. I don't think it can because it wasn't argued to the district court. And I also think if you look at Oroville, it doesn't really change the outcome in this case. The Oroville court, if you look at that opinion carefully, was very concerned with causation. The Oroville court did not say that you built the system and it caused the flood, therefore you're liable, which is effectively what the appellants in this case are asking for. The Oroville court concentrated on causation. I think if you look at that case, it's instructive as to what you need to look for. And you need to look for deliberate decisions by the court or by the municipality that caused that flood. For instance, the Oroville court warned that you need more than just a causal connection between the improvement and the damage. I.e., you can't just say you built a sewer system and I've got a backup. The court said you need more than that. If you look at the Oroville decision on page 312 of the Pacific Third site, they actually said a court assessing inverse condemnation liability must find more than just a causal connection between the public improvement and the damage to private property. And they went on to say, what we hold is you need to find substantial causation for that. But what the appellants are arguing today is all we need to do is establish that causal connection. You built a sewer and we had a sewer backup.
In all fairness,
guess
Mr.
it-
Fagan, I just wanted to say this and I'll leave you alone here for a minute if I can. I don't know if I can, but I agree with you about that, about Oroville. And I think there's language in Oroville that goes farther than is needed to address this case and arguably goes farther than what our cases suggest, for whatever it's worth.
And I agree with that, Judge Sanders. I'd also point out, you mentioned the inherent risk issue. In Oroville, they also mentioned that too. In Oroville, they cautioned that a link to one of the aforementioned inherent risk, and this is at page 314 of the Pacific Third site, a link to one of the aforementioned inherent risks is necessary, but not sufficient for a successful inverse condemnation claim. The plaintiff must also establish substantial causation. So what the Oroville court's saying there is, just because you show that your damage, it was an inherent risk, that's not enough for an inverse condemnation claim. You must also show that the city substantially caused that damage. And in this case, there's no evidence that the city substantially caused that grease backup. The only evidence that's in the record in this case, the only evidence, is that it was caused by other users illegally interjecting grease into the system. And that's in the record in two different affidavits and the deposition testimony of city witnesses. Scott Emmerich, a public works director, submitted an affidavit stating that, and John Alston, an expert for the city, also stated that.
Mr. Fagan, I guess I'm a little puzzled why you're so resistant to Oroville, because it seems like what you're arguing is that it supports the city and that it would maybe be helpful if the case did go to trial in instructing a jury about how to determine a government's liability, because it has to show more than just a connection to the inherent risk. And what plaintiffs are asking is that we remand for trial on causation and damages after concluding that the city could be held liable in inverse condemnation if there's this substantial causation from a deliberate decision in planning and building the system. So if the case were remanded for trial, wouldn't Oroville help your argument?
Thank you, Justice Baker. As I said, I don't think the Oroville case changes the decision. I do think it's improper to consider it because it was never argued in district court.
Well, I understand, but
for that reason alone. The other issue I'd address, Justice Baker, is that I don't see the factual record in which this court could remand on causation, because there is no evidence in the record other than the fact that this backup was caused by the illegal interjection of grease, and the city didn't have a role in that. Without any facts to support a causation, an alternate causation finding against the city, I don't think this court has a basis to reverse the summary judgment order by Judge Moses. I do think Oroville is instructive because it is not a panacea in my mind for the appellant's case, because it does say you have to look at, did the city deliberately make a decision that actually caused that backup? And if you apply it in our case, there is no evidence to show that the city made any decision or made any choice that actually caused this backup. What it was caused by was by users interjecting grease into the system against the ordinances. And that's the only evidence in the record that establishes that. But Oroville is helpful in several respects, in that it tells you that you can't just rely on an inherent risk being present, or that if a backup happened that's linked to the sewer system. It's also instructive because it cautions pretty strongly against strict liability issues. It's a concern with that too. And I think this court.
But Mr. Fagan, we need to stop with this conflation of negligence or strict liability with our tort law concepts into the constitutional language of our provision, which is identical to the Constitution of California, that talks about damage. This is not just a taking case, it's a constitutional damaging case. And introducing and analogizing tort concepts here is just confusing and conflating the issue, in my view. I don't understand how we keep coming back to that.
I guess what my point, Judge Sandifer, and I apologize if I'm confusing, is that I think under Rouser and Lodge Deschner, the two existing cases, it needs to be shown that the city took some deliberate action or made a deliberate choice in constructing or designing or maintaining their system that caused the appellant's backup. And there just simply isn't any evidence in the record that they did anything like that. As you know from the Evanhouse case or Evanhouse case, there can be instances where a city can be shown to have made a decision that caused a backup. They may have made a decision to not maintain a system and just let it break. That's an actual decision that I think fairly can constitute a takings, because the city did make a deliberate decision not to do something that caused the damage. Or a city could maybe cut corners. I think the Orville case discusses that. Could cut corners in designing their system to save money, but by cutting corners, they actually presented a bigger possibility of causing a backup. That would also be.
I think what's confusing about how you're discussing this, that I think maybe what Justice Sandifer is alluding to, is that terms like cutting corners or not maintaining invoke concepts of negligence. But what it seems to me was being discussed in the Rouser and the Oroville case are things that governments have to look at in doing a cost benefit analysis. If the government decides that there is going to be some risk of the project, but it's a public project that the government has to undertake, and that the risk is minimal compared to what it would cost to be an absolute guarantor of no problems, that's a decision the government has to make. And the question is whether that decision led to the plaintiff's injury, and whether then that is compensable under inverse condemnation.
And I apologize, Justice Baker, if I am being confusing. I think my basic point is that you just need to look and see, did the city make some type of decision that actually can be shown to cause that backup? You need to have some sort of deliberate decision, deliberate action in designing, constructing, or maintaining that system that can be shown to be the cause of the backup in question. And if there's no evidence of that, then there cannot be a valid inverse condemnation claim. So that's my only point, is that we need to review that and see, did the city make some sort of decision somewhere along the line involved with their system that could be shown to be the cause of the action. And Rouser, the court carefully considered that. They considered, what did the irrigation district know when it decided to build the project, and can that decision to build the project with that knowledge could it constitute an actual affirmative decision by government that took property? That's the basic issue here. And I think that there isn't that evidence in this case to show that the city took some type of deliberate action that can constitute an affirmative government decision to take property.
Mr. Fagan, then, and I'm sorry for picking this with you, but this is important. And you're not the only one who's doing this, but the court did this. I think it appears in some of the both sides briefing, but the statement that there needs to be intent to take property is fine if we're talking about a taking in the Fifth Amendment sense, and to the extent that our state constitution talks about takings and compensation for takings. But our constitution, like the California Constitution, provides constitutional protection for damaging of private property by the government in furtherance of public uses. And so the idea that this isn't a taking doesn't get us anywhere, in my view, because it doesn't address the broader language of the state constitution.
Let me clarify the intent issue too, Judge Sandifer. So the intent is not to damage something. The intent is to make a deliberate government decision that could be shown to have taken property. And the outside case law that we submitted to the district court and to this court in our brief, there's 8 different courts, I think, that we submitted that all address this same exact issue. Can and sewer backup that was inadvertent constitute a takings by that municipality? And I think at least 4 of those cases, 4 or 5 of those cases are Supreme Court decisions by various states, including Nebraska, Oregon, Texas, and Vermont. And those courts all ruled that that does not constitute a taking because something more than just an inadvertent or passive taking a property needs to be present to constitute a taking. And I think that case law is really important because it shows, in my mind, that you need to be looking for an actual affirmative decision by the government that could be said to have caused that property damage, because it does have to constitute a taking of property by the government.
But that's my point, Mr. Fagan. I have no problem or qualm with those cases to the extent we're talking about a constitutional taking. But my point is that the Montana Constitution, like the California Constitution, applies broader than just to constitutional takings. It expressly does. And so to the extent that we have a takings analysis, that can be correct on its face, but doesn't dispose of the issue here under our Constitution.
Well, I would note, Justice Sandifer, that many of the cases that we submitted, I think at least 4 of them, have a nearly identical constitutional eminent domain provisions as to Montana. They include the taking or damage portions of Article 2, Section 29. So they do apply the same standard. And those courts were struggling with the same thing that the district court and this court has to struggle with. Can a takings occur simply by building a sewer system that caused the backup? And those courts all ruled that no, that does not constitute a taking of property by the government, because you need more than that. You need a deliberate government action that could be said to have caused that backup. So I personally think that the court acted appropriately in denying this claim. It looked at the relevant Montana case law. It applied that appropriately. It looked at the outside jurisdictions that have addressed this identical issue, used that as persuasive guidance, and it looked at the facts in the record. And the facts in the record in this case were that there is no decision by the city, no deliberate choice or choice of design, manufacturing, construction, or maintenance that caused this backup. And without that being present, there can't constitute an inverse condemnation claim. There perhaps could be other torts available based on that. There can be, a negligent tort or nuisance or trespass or something like that, but it doesn't constitute inverse condemnation. And I think that's important, because inverse condemnation carries with it, as this court knows, the award of attorney's fees to a prevailing inverse condemnation plaintiff. And that's really important, because if we set a standard today that basically makes a municipality strictly liable for a public improvement that may cause some damage, you're going to see a flood of other cases related to other public improvements that may cause damages too. And I think a good analogy is building a city street. There's an inherent risk by building a street that you're going to have car crashes. We can't rule that out. That's pretty much inevitable. If you build a city street, and that's a public improvement, if you build that with that inherent risk, and if this court rules that that's all you need to get inverse condemnation claim, then when somebody gets into a car wreck and has property damage to their car, they're going to have a recognized cause of action for inverse condemnation against the city for building that public improvement that had that inherent risk.
Mr. Fagan, that's a red herring. Excuse me, Chief, you go ahead.
Well, I was just going to say, perhaps in a different way, that you still have to have your inherent risk has to substantially cause the damage. So in your analogy to building a street, you could go to a negligent design, which of course there are cases all the time, but just building a street alone, without something else is not going to substantially lead to that damage. That inherent risk that the car might crash that doesn't cause a person's damage. It would have to be some kind of a negligent situation, right?
And the reason I bring that up, Justice McGrath, is I do think the appellants are making the argument that if you build a public improvement and you understand there's inherent risk to it, and that inherent risk occurs, then that's an inverse condemnation claim.
But Mr. Fagan, just to add to the chief's comment and to touch on something Justice Shea suggested earlier in this argument, we have a very well-developed causation law that addresses both causation in fact and legal causation to the extent that superseding intervening causes cut off liability. And that causation law would readily cut off the type of runaway liability for the unbridled strict liability that you're trying to say is the danger that's going to result here if there's compensation for people like the Wittmans in this circumstance. And I just respectfully can't let that go.
But the reason I bring up the analogy to the city streets is because I do think this court has to be cognizant of the fact there could be unintended consequences if the court would make a ruling that essentially presents strict liability for municipalities that build public improvements. And I think the way to avoid that is to stick with the requirements that there needs to be shown to be some type of deliberate decision or choice by the governmental entity in constructing or maintaining their public improvement that can be said to have caused the particular damage at issue. And if we stick with that, I think we're in a lot better place going forward in these claims. And I think if you stick with that, the decision in this case has to be to affirm Judge Moses's decision, because there's no evidence to support the fact that the city did anything that actually caused this damage.
Very good.
But with that being said, I have less than a minute left, and I don't have anything else to add unless any of the justices have a further question for me. Okay, thank you. I appreciate your time.
Mr. Gannett.
Thank you, Chief Judge. If I may kind of start off where the discussion with Mr. Fagan left, I would just like to point out that this court has already undertaken the analysis to draw very clean lines around the or damaged language in our constitutional provision. They did that in both, or this court did that in both Booman and Kafka, where it resisted the request to extend these or damaged cases into the realm of regulatory takings. Now, it would be my position that a regulatory taking, where the government enacts legislation that essentially eviscerates, in those cases, it was the alternative game farms. That's a much closer call than someone driving down the street incurring bodily injuries in a car wreck, which, by the way, is not contemplated at all by our Constitution, and personal property damage, which, once again, is not really contemplated by our Constitution. So I think that this court already has the support to set aside these outlier runaway liability type cases. The next thing I'd like to say is there's this repeated reference to the illegal discharge of grease. And I think it's really important to understand that there is no illegality in cooking and eating bacon in your home and washing those dishes and washing those pans and washing that grease down the drain. Now, we all try to do the best we can. We all try to pour as much of that grease into a can or into the garbage can. But in the deposition of the city's expert, I asked him, how do you comply with that ordinance, even as an industrial user? And he said he didn't know. I asked him, he's the superintendent of the Bozeman sewer system. And I asked him if he had ever discharged grease in his home in excess of the 100 milliliters or milligrams per liter. He said, I'm sure I have. There is no illegal discharge at play here. I'd also like to address, earlier we talked about, the city opens up with the notion that this case has statewide implications. And then shortly thereafter, it says, well, of the 10 to 15 overflows, only 1 or 2 of them are caused by grease. So it's not as big of a statewide problem in that breath as it was to begin with. And again, the court in Oroville looked at whether or not, I believe it was tree root intrusion in that case, whether that was an inherent risk of operating a sewer system. And it said, tree roots go towards moisture and pipes have cracks in them and tree roots will get in there. And so tree roots is an inherent risk. And then on the causation side, they said that the plaintiffs did not prevail. So Mr. Fagan mentioned that sometimes there are rocks in the sewer, sometimes it's construction debris, sometimes it's these flushable wipes that actually aren't flushable. Well, that's the exact analysis that takes this outside of the realm of strict liability. First, we have to decide if the clog at issue was caused by an inherent risk of operating the sewer system. Next, we have to decide if that was a substantial cause. And again, this is the Oroville test, but it's the exact same under Deschner. First, we decide if as planned and built, this approximately caused damage. Article 2, Section 29 of our—
Yeah, I guess then I'm still struggling with what about the planning or the building of this sewer system caused this. I mean, it just seems to me, and this goes back to the Taylen case, where we specifically addressed the fact of the intervening causes. It seems to me that the discharge of grease or whatever other items that might cause these clogs is an intervening cause. I mean, if the focus is on the planning and the building of the sewer system, what about the planning and building of this sewer system caused this backup, absent the discharge of the grease?
And in response to that, Justice Shea, I would say if that were the test in inverse condemnation, then in both of the Knight cases, it was not the construction or the widening of the road, for example, in Billings, that caused the damage. It was all the people that drove on the road. I mean, it's the cars that created the traffic, created the additional noise, created the pollution, and ultimately devalued the homes. But that was an inherent part of widening the road. In fact, it was the purpose. We want to turn this from 2 lanes to 5 lanes so that we can allow more traffic through now what's going to be a main thoroughfare in Billings. We have to step away from the idea that there has to be an intent or desire to cause identifiable harm and understand that our eminent domain provision is kind of like 2 sides of a coin. On the one side, we have categorical takings, which require an intent to take property. Again, going to Knight Billings, the city went to the property owners on the east side of the road, condemned all of it, paid fair value, and expanded the road. That intent element is necessary on the categorical taking side. On the other side of the coin, we have the consequential damaging cases. This is Root Butte, Less, Ebby, Rouser, the Knight cases. And again, this Knight Billings case is a good illustration because while the city may have intended to categorically take the property on the east side of the road, what they didn't necessarily intend was the diminished home value on the west side of the road where they didn't take it. They didn't initiate condemnation proceedings, but it's still an inherent risk of widening the road. And so the focus has to be, in my opinion, and based on my study of existing condemnation law in Montana, It has to be on whether or not this is an inherent risk. And again, the idea that it's the people pouring grease into the system, I would venture to say that's nearly everyone. We have
One thing we
32,000.
said in the Knight versus Billings case that was part of our conclusion, in addition to the explicit condemnation of properties on the other side, was the 20 to 30% property value reduction, because the effect of what happened in Knight was to impose a servitude or limitation on the use and the marketability. And what Mr. Fagan is suggesting is that and I understand your answer to my previous question about depreciation, but he's suggesting that unless the city's design would lead to this kind of servitude on private properties, there's not a record that would support an inverse condemnation claim under the Knight standard.
Thank you, Justice Baker. The city's design does impose this servitude on 10 to 15 people every year. And that has been the case for more than 40 years in Billings. A good way to think about it, and I know that these percentages are going to be a little bit off, but every sewer main in Billings has a 99% chance of getting the sewage past your house and to the sewage treatment plant. But that means that every main has a 1% chance that there will be a clog that will back up into your home and cause this, in this case, it was about $80,000 to fix this problem, which if we looked at as a percentage of the home value would be about 30% of this home's value. So with my dwindling 4 seconds here, I'd say thank you for considering this case and our arguments, and it has been a pleasure.
Thank you to all three counsel. That concludes our oral argument on this case. The court will take this matter under advisement, and a decision will be issued in due course. But I do want to take this opportunity to thank the State Bar for having the court conduct an oral argument at the annual meeting. I want to take the opportunity to thank the law school for providing the introduction and putting an effort into this plea. And as I mentioned, thank you to all counsel. Case was well argued, and we'll see how it comes out. Thanks very much.